particularly Babak Hamid and Hamid Sabi for asking me to come along and participate in this event. And I think, as with everybody else, the Iran Tribunal adds yet another milestone in the development of civil society initiatives to find a mechanism for justice where there has not yet been a more formal notion of justice that's been delivered by the international community. My comments today are based not only on my participation in the work of the Tokyo Women's Tribunal, but also my involvement in the issue of the comfort women since 1993. I first became involved in the issue at the request of the International Commission of Jurists to look into this issue in 1993 and produced a preliminary and then a final report for them through 1993 and 1994, and then stayed involved with a range of organisations working on the issue from that point in time. And in fact, I'm still involved with a number of organisations in Japan and Korea. As a range of people noted this morning, these civil society initiatives grow out of the sense that atrocities have been committed and that justice has not been done for the survivors or the families of victims of those atrocities. And although he hasn't yet come downstairs, I just want to acknowledge the work of Andrew Byrne in moving our reflections on these civil society initiatives to, or into a much greater extent, moving it into a much greater extent to the literature on international law, because I think a lot of work was done and a lot of publications have been made by non-government organisations, but now this really is an academic study about the work that these groups do and what contribution they actually make to international law and international relations. And I know the people who are at the seminar on Thursday and Friday have some views about the role that historians, sociologists, and anthropologists might play in studying these initiatives and also making it the subject of serious academic commentary. One of the reasons that we held the Tokyo Women's Tribunal was to influence the processes used by the more formal structures. At the time the decision was made to hold the Tokyo Women's Tribunal, the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda had been established. And there were a lot of criticisms of both of those tribunals as to the way that they treated women, both in the way that women gave evidence before the tribunals, and some disparaging remarks that have been made by judges, and also an initial unwillingness of both tribunals to look at crimes of sexual violence and crimes that had a gender base to them. And so part of what we were trying to do is say, there are other ways of dealing with this, and you need to think carefully about the people who come before you as witnesses. And I'm going to come back to some of the things that we did a little bit later. One of the things that came up through the process of our tribunal, and I do want to highlight before I go into some of the details about the tribunal, is that I think all people organising civil society initiatives and those people who are involved in the more formal mechanisms of justice need to give greater thought to marginalised and disadvantaged groups. Clearly, our tribunal was focused on women and girls, and one of the things that I want to say, and I will highlight a couple of times, is that although the Tokyo Women's Tribunal was said a women's tribunal, and the phrase, the comfort women, is what we use to describe these women that were taken by the Japanese military. In fact, a significant proportion of them were girls. Some of the women that we interviewed were 13 years old when they were taken by the Japanese military. And so you are looking at two groups, certainly at that point in history, who were marginalised within their own societies, women being given an unequal status, and certainly girl children being given a very unequal status. But I'm not sure that we still pay enough attention to groups like the disabled and the elderly. I'm not sure how many of you are aware, but if you are a disabled person in today's world, you run a risk 5 times greater than the average person of being trafficked. And so I think there's still a long way to go in looking at the various groups that are severely marginalized and disadvantaged, and making sure that we as civil society organizations take account of the various forms of disadvantage that people suffer. Like many other people have spoken today, I have certain views about why people's tribunals arise, and like some of the previous speakers, clearly it's the fact that no one has been brought to justice for acts they've either committed, condoned, ordered, participated in. And I want to just read out a statement from the Basic Principles on the Right to Reparations for Gross Violations of Human Rights, that all states have an obligation to provide those who claim to be victims of a human rights violation, human rights or a humanitarian law violation, with equal and effective access to justice, irrespective of who may ultimately be the bearer of responsibility for the violation. And I think that that sentence sort of encapsulates what it is that all the people's tribunals have been trying to do, because the formal mechanisms have failed us. I think it's particularly difficult in the sort of situation that was addressed by the Iran Tribunal, where you're dealing with issues of power, people who committed atrocities, who still wield positions of power in a country, and where the situation in a given country is one where oppression is still taking place. In a sense, our job at the Tokyo Women's Tribunal was easier because the event had taken place so far in advance, so far in the past, that in one way it was easier to get the support of the general Japanese public. And I would like to highlight here, because it's something that I think gets overlooked a lot in discussions of the Tokyo Women's Tribunal, of the amazing support that we receive from ordinary people within the Japanese public. The ongoing problems are with the Japanese government, not the people of Japan. And obviously, as in any country around these issues, there are divergent views within the public, but a significant amount of the money raised to hold the tribunal came from street corner cups that were held out on the streets of Tokyo and other major cities in Japan, and seminars where people came along and purchased papers. So this is not a situation where people were necessarily going against the wishes or were working against public sentiment in Japan itself. Because the situation of the comfort women relates to armed conflict, I'm going to focus my remarks on trying to get justice for people who've been exposed to crimes against humanity and war crimes during armed conflict. And one of the issues that comes up, and I think is also relevant to the sort of situation faced in Iran, but certainly is a major concern when you're dealing with situations of armed conflict, is the notion of partial justice. The reality is that we do not have the resources to try everyone who participated in, ordered, condoned acts of atrocities. If you think about, let's say, the Yugoslav Tribunal, close to $1 billion has been spent for some 20-odd trials. So that is the reality of the resources that are there. You are just not going to bring everyone to a formal mechanism, at which point it becomes really important to think about the alternatives to that, one of which is obviously a People's Tribunal. There are Truth and Justice Commissions, but again, other speakers today have highlighted, and I'm not going to go back through, the role of international politics, domestic politics, in establishing Truth and Justice Commissions. But there are serious problems about getting enough of those officially sanctioned commissions established. And so I think this issue of partial justice will always lead to the establishment of civil society initiatives to look more deeply into the background to particular situations of oppression, particular situations of conflict. One of the things, when I first became involved in the comfort women issue, there were three things that struck me when we first did our mission going through the Philippines and North and South Korea, interviewing women who have been subjected to the system. And I suspect that this will come through and has come through to some extent in the discussions around the Iran Tribunal, but no doubt will come through in the film this afternoon. But even for those who look like they were able to lead some semblance of a normal life, the reality is they had never recovered psychologically, and for many of them physically, from what had happened to them. For those who had suffered physical injuries, they were a constant reminder of what they had had to endure, and a range of them had ongoing post-traumatic stress disorder or other psychological disorders. And coming back to the remark I made earlier about the age at which many of these people were taken, there was this ongoing, what some might describe as a never-ending source of grief about the loss that they had suffered, remembering, as I said, that some of these girls were 13, 14 years old at the time in which they were taken by the military. They lost their childhood, and they lost every dream that they ever had about their life. And this was a never-ending source of grief to them. And so these women now in their 60s or 70s are still grieving over the childhood that they never had and could never experience. And of course, that grief was made worse by the fact that nobody had ever been made answerable for this, but also, and I cannot highlight this enough, the silence that these women were made to endure. And some of it, you might say that, they chose a lifestyle, but of course it was their societies, and I think we still need, given the range of inequalities that exist in all societies around the world. Certainly for the Korean women, many of them never went back to their families. They just could not bear the shame of telling anyone what they had suffered. And so they never went back to their homes. They chose to live a life where they never had any friends, never talked to their neighbors, for fear that they would reveal what had happened to them. Now just think for a minute what would it be like for living for 60 years, trying to avoid all human intimacy in order not to reveal what had happened to you, and what the ongoing psychological trauma of all of that is. And for some of the women from the Philippines, from the Netherlands, and others that actually did reveal what had happened to them, and who eventually did get married, every time there was a marital argument, their husbands would refer to them as whores of the Japanese. So this is the ongoing consequence for them throughout their lifetimes of what it was someone else inflicted on them. But the other thing that struck us through the years working with these women was not only their need and their desire for a sense of justice of what had happened to them, but what prompted a range of the women to come forward and actually, after all of that time, start talking about their experiences was what was happening in the former Yugoslavia. They could not believe that that sort of systematic violence was happening to women yet again in their lifetimes. And so it was not just about themselves, but they wanted vindication for women worldwide and the international community to begin to cope with the sort of gendered violence that gets committed against women during armed conflict. And that commitment to justice was there throughout the proceedings. And given what the emotional toll it took on so many of these women to come forward, it really is quite inspiring to think about that commitment to justice and their willingness to talk about their experiences. We don't know how many women were subjected to this system, and I'm not going to go into enormous detail, but just one of the things about the Comfort Women's system that I think it's important and relates to some of the remarks that Paya made earlier about the role of the international community and also about the moral disorder and the social decay that takes place is the estimates range from 100,000 to 200,000 women across the Asia-Pacific region. Everywhere the Japanese military went, they set up these comfort stations. And in the documentary evidence that has come to light over the past 20 years or so are copies of orders that were actually given by the Japanese military. And I'm just highlighting this because it's the bureaucratic nature of this. And remember, these are talking about human beings, where you have documents that say, we need 20 women from such and such a region of Korea or Taiwan, and they are to be at this particular port on this particular day, put on this particular ship, they will arrive at this particular port, this regiment will meet them, and they will be sent out. And it's all in bureaucratic language. And so just the ability of people to deal with other human beings in that way has to be brought into question. And to be thought about of what allows us, and everyone in this room, to think about what allows us to deal with other human beings in that particular way. When I first started, I made some remarks about the fact that often it is people who are in particularly disadvantaged groups that end up being targeted during periods of armed conflict or domestic uprisings. And I'd just like to read a couple of paragraphs from the judgment that was issued at the end of our tribunal, because I think they highlight this issue of what happens to people who are already marginalized in a society, because of course it's what continues to happen in the world today. The Japanese military preyed on the most vulnerable members of society for its sexual slavery system, those who, because of age, poverty, class, family status, education, nationality, or ethnicity, were most susceptible to being deceived or otherwise trapped into slavery. Many, if not most, and in quotes, comfort women, came from poor rural households where the girls had had to go to work at an early age to provide support for their families. Some of the witnesses testified that at the time they were enslaved, or they were still just girls, they had already been working outside the home, already living a difficult life. They were among the most underprivileged people in their own society. And I think, again, for those of us who work on this issue of people's tribunals, it is important to make sure that we turn our attention to the full range of people who've experienced horrors in any given situation. There were, in a judgment that was issued at the tribunal, several sections concerning the long-term effect of being trapped in the comfort women's system and what it had done to the women. And again, I'm just going to read out a couple of little bits from the judgment because I think it does encapsulate this issue of enduring harm and continuing harm, and it was raised by previous speakers, and I'm sure is a part of the initiatives that some of you have worked on, including the Iran Tribunal, but I think it is really important to constantly highlight the fact that this is not something that happens and then it comes to an end. People live with this for the rest of their lives. Under the heading Enduring Physical Suffering, the judgment had this to say: Two survivors mentioned digestive problems caused by torture. Kim Young-suk suffers from digestive problems as a result of being cut in her stomach with a sword, and Kim Bak-dong suffers from having water forced down her throat with a hose. Chun Ok-sun lost her ability to speak as a result of tattoos that were imprinted on her tongue. She also lost one eye as a result of violence. Now, I made a purposeful choice here not to talk about the sexual violence because that's gotten a lot of media attention. And one of the problems of referring to this as the comfort women system and as a system of sexual slavery is that we forget every other form of torture that these people had to endure during that system. Under reproductive harm, 6 survivors testified that they were unable to bear children. Mrs. X and Ms. Suhana testified that they had had their uteruses removed due to infection as a result of sexual violence. Pak Young-sim testified that a doctor in the POW camp removed her womb after she had a miscarriage, and Chung Seung-myung and Lee Sang-gyung lost their wombs as a result of torture. And of course, those were people who testified at this tribunal. If you go through the records of a range of the comfort women, you'll see that that was an experience for many of them, that they had lost their reproductive ability. I think I'm becoming aware of my time, so I'm not going to sort of go through all of the things. And I've talked about the silence that many of them had to endure and the effect on their lives. I would like to highlight the testimony that was given by one of our expert witnesses, who is a counselor for women in the former Yugoslavia, because I think it also encapsulates some of the reasons why people have engaged, some of the things that I've said this morning, and why many people engage in these civil society exercises. Lepa Mladenovic testified that social justice was an important part of recovery for survivors of sexual violence and armed conflict. Trauma is not the private matter of a woman, but a political issue. When the state takes responsibility for sexual violence, it can contribute to the survivor's recovery, and I would say the same for the international community. And conversely, when it refuses to take responsibility for the crimes, it can impede the survivor's recovery. And I've no doubt that those of you who participated in the Iran Tribunal are well aware of the second part of that statement. I was asked to speak about the tribunal, and I think some people are familiar with it, other people are not. It was perhaps one of the more legalistic people's tribunals that has taken place. It was conducted as if you were holding court proceedings with a panel of judges. Patty Sellers and I acted as co-chief prosecutors. And the reason that Patty and I were asked to join the team is that we had 7 different countries that were participating in the tribunal. And so trying to bring everybody together and work through common threads was an important part of the exercise. Through all of this and getting agreement from all the 7 different countries as to how this would be approached, who would be named as defendants. But I'd also like to highlight, because some of the commentaries on our tribunal seem to suggest that it was the organizers who came up with this idea to have this particularly legalistic framework, and that is not in fact the case. It was the women's organizations, because there were groups in each of the countries that participated who have been working for a considerable period of time with the women. And those groups were the ones that elicited from the women themselves the sort of tribunal that they wanted. And they were very clear about wanting this far more formalistic structure. Now, today is not the place. At other meetings, including one in Rome last year, I've raised some questions about why it is women, many of whom never even completed primary school, felt that this formalistic legal structure was what they wanted, when inevitably the very nature of a formalistic legal structure meant they were going to be excluded in part from its organization and from some of its language, is an interesting question in itself. But as I said, I don't have time today to explore that, but I think it is an important issue to address in the context of these tribunals, of how you match the expectations of the survivors with their conception of what justice means, as well as the whole notion of what it means to be holding a people's tribunal. Andrew said that maybe I might say something about the connection between our tribunal and more formal processes. I'm going to come back to most of that, but I would say that one of the issues that some of the academic commentators raise, and again, I think it is an important thing in terms of those people who have influence with their governments that fund places like the International Criminal Court, is that what the women who had experienced all this did not know is that it's not true to say that none of this was discussed at the Tokyo war crimes trial held at the end of the war. Information, in fact, was put in front of Tokyo, but it was done to prove how the Japanese were waging an aggressive war. And so it was done to establish how awful the Japanese were vis-a-vis the way they conducted the war against the Allies. So, for example, Germans who were resident in China, and in theory Germany and Japan were allies with one another, Germans resident in China who had actually protested to the Japanese government about what was going on were called to the Tokyo Tribunal and actually testified about what they had witnessed in terms of the treatment of women. And information was also put into those trials about massacres of Filipinas and the fact that many of them were raped before they were massacred. But it was not used to say that they had actually committed crimes against particular women, nor to address this particular issue of sexual slavery and enforced prostitution. The other thing that I think is important in thinking about our formal structures, and although the International Criminal Court is certainly much better than either the Nuremberg Tribunal or the Tokyo Tribunal, is that one thing we cannot get away from is that inequality exists in every country around the world, and we do not have a justice system anywhere in the world that actually recognizes full equality. Women who come before the courts domestically, who are alleging that they experience crimes of sexual violence, will still feel that they are marginalized and excluded by that system. And a report done by UN Women compares people who claim to have been victims of robbery versus people who say that they've been victims of sexual violence. If you look at people who say that they were victims of robbery, 37% of those will come forward. Only 17% of women who've been subjected to sexual violence will ever come forward to even say that they have been subjected to the crime of sexual violence. And it's their knowledge of what will happen to them when they come into the criminal justice system that acts as a barrier to their coming forward with these events. Now, I'm not saying that progress hasn't been made, but the UN Women Report highlights the way in which women are subjected to questioning, forms of cross-examination, suspicions about their motivation, character assassination in the way that other sorts of victims are not. And so when you're looking at these issues, it does become important to remember that gender bias on the part of prosecutors and investigators remains an issue, and I don't think it's accidental that the Office of the Prosecutor for the International Criminal Court has recently adopted a policy on gender bias with respect to crimes of sexual violence, because of the recognition that this remains an ongoing problem in our international system. But coming back to the Tokyo trial, the actual Tokyo war crimes trial, the Allies were well aware that the comfort women's system was in existence, and some of the documents we used at our women's tribunal were actually documents that had been produced by the Allies. They referred to the comfort women as amenities in the Japanese armed forces. So once you have done that, of referring to these women as a form of amenity, talk about bureaucratic language as well, and they also, in some documents, referred to them as camp followers, which is a euphemism for prostitutes. The moment you had done that, it meant that no investigator, no prosecutor at the Tokyo trial was ever going to look more deeply and think through whether or not charges could have been brought against some of the Japanese commanders for what was then the crime of enforced prostitution. There's no doubt they could have done it if they had wished. There was a crime in existence, but nothing was done to really look seriously at this. And so, yes, we've come a long way since then, but I think there's still a range of issues with our present international system. In terms of the structure of the tribunal, the Women's Tribunal that we organised, in addition to having the women come forward and a range of experts, we had experts who testified about the structure of the Japanese military, about the emperor system, and I've highlighted already the psychological witnesses that came forward. One of the things I have to say that in some ways fed into the fact that we did and could in fact conduct what was a fairly legalistic proceeding was the fact that there were thousands of pages of documents available to us, both, as I said, from what was available from the Allies themselves, or what the material they had collected, but through the very hard work of some Japanese academics who had gone through a range of files that had been buried in archives, and they started finding all of these documents, and then they got translated into English. And one particular academic, Professor Yoshimi, his work was absolutely crucial to bringing the full extent of this system to light and coming up with the range of documents that could be introduced before our tribunal. I'm not going to go into any greater depth about our tribunal. I'm happy to answer any questions if people want more information about its particular structure. But I do want to raise one sort of more issue which I think requires thought, because this seminar and the one on Thursday and Friday is not just about the tribunals that have taken place in the past, but what may occur into the future. And when we organised it, we were looking at things beyond just saying that certain people were responsible for those acts. There was some hope that textbooks in Japan would be changed, maybe memorials would be created. But in addition, for those people from Japan who participated in this, there was a recognition that the militarism that had permeated Japanese society prior to the war still had some effects at the present moment, and that the rise of an unthinking nationalism in Japan was again beginning to undermine the effective operation of democracy in Japan. And so one of the motivations of the Japanese participants was to highlight these issues and the connection between the militarism that had allowed the comfort women's system to be established and what was happening in modern-day Japan. Now, one of the problems, of course, with organising such a legalistic framework, and this may relate to some of the comments that were made this morning, is that at the end of the day, I don't think we did any better job of addressing the political ideology and the sociological factors that contributed either to the establishment of the comfort women's system or the ongoing nature of the sorts of remarks and issues that were happening in Japan prior to the tribunal, and which we still see today, where people either deny the existence of the comfort women or make very derogatory statements about the women, or keep wanting to suggest that they all volunteered. Suddenly, 200,000 women across the Asia-Pacific volunteered to go and follow the Japanese troops. So I don't know that we, as I said, did a better job, and it may be that in organising some of these tribunals, more thought needs to be done about how you keep faith with the victims who want to tell their story, but also how you go about exploring the larger political context in which these events take place, whether more of an historical, anthropological, sociological framework needs to be introduced into the holding of people's tribunals. I'm not suggesting for a second that I have any answers. I'm just raising this because I think it deserves some thought. But it does, because part of this initiative, and Payam sort of made reference to this, is on the one hand, everybody is aware of the societal disarray that takes place that leads to these mass violations of human rights. And one of the reasons that people organise people's tribunals is to reassert some level of morality, and they want a societal transformation that says this is not going to happen again, but then we don't end up exploring what's necessary for that societal transformation to actually take place, whether domestically or internationally. And so I think those people involved in future efforts, or those academics who are working on this, perhaps more time and attention should be given to those kinds of issues. And I have already talked to some extent about gender equality, but I would close because as someone who's taught women's rights and human rights and definitely has a feminist take on a range of issues, both in interpretation of human rights law and international criminal law, it would be remiss of me not to close by highlighting a comment that was made by Naveen Pillay, as the former Human Rights Commissioner. The inequality in the law exists in all regions of the world and in all legal traditions. That when we're organising these civil society initiatives, we have to also interrogate ourselves of what prejudices we bring, what attitudes we bring, making sure that if there are prejudices and attitudes, particularly towards women, that would mean issues that were particular to women in a given situation were not being foregrounded, that something is done to change that scenario. Thank you.